Hello YouTube, I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. We have a question here from YouTube user Desil, or spelled D-Sil, which I will now be pronouncing as Diesel, as in diesel. So I'm going to assume that you're Diesel Cecil. Although I have no reason to believe your name is Cecil. It's just how your username looks to me. Okay. And Diesel says, if your attorney settles your case without asking you about it, can that settlement be voided? And can you then get a new attorney? Okay. This is a constant issue in our industry, and it shouldn't be. It shouldn't be at all. So, first and foremost, let's deal with the lay of the land in terms of the law. So, an attorney cannot settle your case unless you grant them authority to do so. But be careful. Sometimes they'll send you a document that you agree to, and in that document, it grants them some kind of authority to settle your case. Immediately, I would argue that is not explicit enough, but I'm not the sun, the moon, and stars of attorney ethics, and ethical boards allow and don't allow things that I think are silly all the time. So, right off the bat, you got to check to see if that's in play. And if it is in play, it may or may not be sufficient authority for your attorney to settle your case wherever you are. Check with local ethical authorities. But, generally speaking, without some kind of authority to settle your case, an attorney may not then settle your case. They may not accept a deal for you. They don't have the authority, unless granted so explicitly, to do that on your behalf. However, the plot thickens. Now, well, let's just deal with your question first, and then we'll go into the whole side rant of related events. Let's assume your attorney had no authority to settle your case of any kind. So let's just create a hypothetical. Your attorney goes out and settles your case for 20 grand without ever asking you about if you want to accept 20 grand or not. So your case is now completely disposed of. Hypothetically, the case is settled. Releases are executed. I have a question. Why did you sign the settlement agreement? Did you sign the settlement agreement, right? If you say, oh, well, my attorney settled my case and I didn't want to settle it, but then I did sign that settlement agreement, then you signed off on that settlement, probably, right? You said, okay, well, I didn't agree to the settlement, but now this document's here in front of me, I'm going to go ahead and sign it. I'm going to execute it. I think there's a good chance that you probably will be found to have opted into that settlement at that point, right? Did your attorney do something wrong? I would say yes. Did you get your attorney out of hot water by signing that agreement? I would also say potentially yes. Now, local laws are going to be different wherever you are. Check with local ethical authorities. If, however, your attorney settled your case and comes to you and says, hey, the case is settled, here's the settlement agreement, and you're like, whoa, 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 I didn't agree to that settlement. The first thing you need to do is not sign the settlement agreement. Take the settlement agreement to a new attorney and be like, hey, I need to get out of this settlement. There's a lot of terms here that I never agreed to, and I never agreed to the settlement amount either. My attorney went rogue. There's a very good chance that you're going to be able to get out of that settlement. Very, very, very good chance you'll be getting out of that settlement in most jurisdictions. Now, the other side may still try to enforce the settlement, saying that they had a verbal deal with your attorney. But that verbal deal is unlikely to encompass all the terms of the settlement agreement. And this is not a sure thing. This is a gray area. Will they be able to enforce the settlement against you? Maybe. Maybe not. I would say likely not, although it will be different from jurisdiction to jurisdiction and even judge to judge, right? Certain judges will absolutely be like, you agreed to it in writing, you agreed to it verbally, so I'm going to hold you to it. The terms are all pretty much standard. You should have known what they were. Boom, your case is settled. I don't think that's going to happen to you often, but it could happen to you. Now, your recourse, if your attorney settled your case without authority, is to pursue ethical and civil claims against your attorney, generally. those civil claims could be hard because you're going to have to prove that you could have gotten more, but for what your attorney did, and that's always hard in our field. But those ethical claims are probably going to go, well, they're going to go pretty smooth for you, I would think, because in my opinion, you've been failed utterly by your attorney's ethical wisdom, right? Settling your case without authority from you is like a baby attorney 101 mess up. So that's generally the lay of the land. Now, where this comes up in our field all the time is lazy attorneys. Lazy attorneys will have a conversation with their client and get a verbal authority, right? This is something that young associates do all the time, where they're like, oh yeah, I'm cool with this client. We've been chit-chatting for a long time. Things are going great. I can take this client's settlement authority verbally. I know we're cool. She or he wouldn't like change their mind. So I'm going to go ahead and I'm going to settle the case based on this verbal authority from a client. Now, this is an act of self-harm in that attorney's behalf. Like, they're just engaged in active self-harm. Because here's what happens. People give verbal settlement authority all the time. But those people giving verbal settlement authority are human beings. So they do a variety of things, like their mood changes. They forget they gave verbal settlement authority. They think they said more or were more clear in their verbal settlement authority than they were. Or their friends and family make fun of them for taking a settlement, and they just decide to lie by giving that settlement authority. All of those things will happen routinely. I'm not mocking plaintiffs. Plaintiffs are human beings. This is what human beings do. If something is not in writing, it will be misremembered to the benefit of the person remembering it. Which is what human beings are. You, me, all of us, I presume. Perhaps there's an alien in our midst, a creature of the ethereal dimensions. I don't know. But most of us watching this video, we're human, and this is what we do. And if you're an attorney settling a case based on verbal, you are just an attorney engaged in self-harm. So, Diesel, when you say your attorney settled the case without your authority, I suspect you mean the attorney just took a settlement and never had a conversation with you. In statistical reality, though, there's a good chance that the attorney got some kind of verbal authority from somebody and settled the case, and now there's an issue over that. So we have a policy, and I spend a lot of my life chasing people around who divert from the policy because they're cool with their clients. No, you lazy SOB, get it in writing, you dumb fluffer, right? And it's never an issue with like tough clients who are like aggressive or like screamers or have like a kind of a contentious relationship with their attorney. Like in those situations, everybody knows to get it in writing. It's the cool clients that you're friendly with, that you like chat with, and you love to work on their case. That's the one. Those are the situations where this goes south, because the young attorney feels chill with this client and is like, yeah, I got you. Let me go get you the 20 grand that you want. Which this is, hopefully that's not what you want. Hopefully you want a lot more than that. But we're talking in hypotheticals, right? So we'll bump it up. Let me go get you the 80 grand, the 100 grand, the 500 grand, whatever it is that you want. I don't need to confirm it in an email. Let's go. No, if I catch you doing that, you'll get your ass fired. It's not how we do things. It's not fair to the clients, because the clients might not understand the weight of their words in the same way that they would if it's in writing and it's very clear cut and it's being reduced to a piece of evidence that will be, enforced, right, later on. Like, then they'll pause and they'll think about it, and they can ensure that the totality of their wishes are expressed, right? So it's not just unfair to the attorney who's going to get schmoffled, just wrecked when that client's like, what? I never told you to settle my case for 500 grand. I want 30 million because my sister-in-law says I'm a dumb whatever, right, for taking this settlement. So I'm going to lie now and say that I never told you to settle the case for 500 grand. Cool. Enjoy those grievances and that civil lawsuit, young attorney. And listen, I get it. I get it. The client was like, yes, please, just give me 500 grand. If you could just give me 500 grand, my whole life would be better. Just get me 500. Weeping, crying, oh, get me 500. And you did it. You did it. You put up the win for that client. That's what that client wanted. I understand that. I understand that. I also understand that client, the minute his or her sister-in-law makes fun of he or she, will turn on you. Not because there's anything wrong with that client. That client is behaving like a human being will behave. It's that simple. That's it. It's that simple. If I turn on this person, this attorney, I can get more. I'm infected with the greedies. My family's making fun of me for taking $500,000. I want more. All I have to do is hurt this attorney and lie and say that I never said that. But I'm not going to lie because I don't have to lie because my mind will change what happened because that's how human memory works. And they'll say, I never gave authority to settle that case. Prove them wrong. It's your word against theirs. And guess what? You had a profit motive, right? Because when you settle that case for $500,000, well, your firm got a cut. And your cut was in the six-figure range. So not only is it your word against theirs, but you had a profit motive to commit a bad act, to lie. It's a bad spot to be in. Don't be that attorney. Never be that attorney. People do it all the time. People are obsessed with it. People will scream at me on their way out the door, telling me, no, it's fine. I can trust that client. Get out. You do not belong in this firm if that's the level of rational self-interest that you're able to muster up in terms of doing right by yourself, by this firm, and by your clients. I don't want to hear it. I don't want to hear it. You're a bad attorney. You're doing bad things. I don't care that you meant well. I don't care that you were cool with your clients. I don't care that you got your client what she or he wanted. Because you didn't dot the I's, you didn't cross the T's. And someone's going to get hurt. And I have no interest in that someone being me or the client. So, you're done, right? So Cecil, I have no idea. Just Diesel. I mean, I'm just adding things to your name at this point. I don't know what went on with you. I'm not saying any of these things that I've been talking about went on with you. Right? The first scenarios that I explained were the scenarios where you, of course, did nothing wrong and the attorney failed you utterly, and I suspect that's what happened in your situation. But I did think covering kind of all the usual suspects for this kind of situation made sense in this video, so I threw some extra stuff out there. And I hope it helps. If it does, like, subscribe, comment down below, share the channel so it can grow. If it doesn't, I'm sorry. Tell me a little bit more about the situation, and I will make you a follow-up video because this is a very important topic in our industry. Okay, take care, everyone.